The Freedom Constitution versus President George Washington, establishing the judicial courts. On September 24, 1789, President George Washington signed an act to establish the judicial courts of the United States. This is a monstrous act, so I'm only going to cover a couple things and the highlights. The act created the district courts and the circuit courts for the areas within the United States at the time. For reference, there were 13 district courts within the United States at the time. Currently, there are 94. The act also created the Marshal Service to protect the courts. A specific call-out I would like to make is that if someone was facing the possibility of being put to death as part of their jury trial, they had to be tried by juries from the place where the alleged crime was committed. And if they couldn't travel to that place, 12 jurors from that place had to travel to where the trial was being held. This act also created the Marshal Service for protecting the courts, some basic rules around appeals such as habeas corpus and writs of error, and stated the Supreme Court, if it was about to hear arguments about a case and received a writ of error from the lower court, it had to push that case back to the lower court and pretend it never heard anything about it. This act by Congress gets into a lot of detail and is really interesting if you're nerdy enough to read it. There's also things like a 42-day appeal period after a conviction for certain circumstances, and it also requires a government lawyer to conduct all prosecutions in all states and territories. So how does this compare to the Freedom Constitution? Well, the Freedom Constitution doesn't go quite as detailed as this. For instance, it doesn't declare district courts and circuit courts in the Marshal Service. So instead, let's focus on what it does say in the Freedom Constitution. Specifically, Article 4 sets up the Supreme Court and gives a list of case types that the Supreme Court is responsible for overseeing. In George Washington's bill, it said that there were 6 Supreme Court justices, 1 main justice, and 5 associate justices. The Freedom Constitution doesn't delineate how many justices there are on the Supreme Court. The Freedom Constitution does say that all trials, except for impeachments, have to be conducted by jury, and they have to be held in the place where the crime was allegedly committed. Jurors cannot travel to the place where it's being prosecuted. The prosecution has to travel to where the crime was committed. The Freedom Constitution, Article 8, Section 2, Paragraph O, has a list of 20 rights or privileges citizens have if they're accused of crimes. I'm going to go through them now, so if you're not double timing this video, go ahead and put it on double time. 1. Ignore questions being asked or disengage in communication. 2. Discontinue answering questions. 3. Be informed of which law the citizen is suspected of violating, when, and the reason why the citizen is suspected. 4. Be confronted by witnesses who support the citizen being prosecuted. 5. Be provided with judicial process for obtaining witnesses to defend the citizen. 6. The right to a legally competent lawyer at the cost of the plaintiff. 7. Be appointed a lawyer within 1 hour of arrest. 8. Speak to a lawyer who represents the best interest of the accused before speaking to the detaining party, plaintiff, or court. 9. End interrogations 2 hours after they begin. 10. Only be provided with information that the interrogator swears under oath is honest during the time of the interrogation. 11. Not be confined for more than 12 hours without being charged with a crime. 12. Competent legal counsel when crafting, submitting, and trying an appeal. 13. A fair trial by 12 members of a community that is similar in size, composition, and affluence as the one which the alleged violation happened. 14. A trial that shall begin within 30 days of initial arrest, and which shall take no more than 6 months to complete. 15. Be tried within the jurisdiction where the alleged crime was committed. 16. Not be tried for the same event multiple times. 17. Not be tried for the same event under multiple statutes. 18. Not be tried for the same event by multiple jurisdictions. 19. Be immediately freed from all confinement, suspicion, and investigations and cleared from all charges when clear and credible evidence demonstrates innocence. And 20. Have all documentation of suspected criminal history held by the government or any government contractors be removed from all public and private sources in all circumstances where 12 jurors did not unanimously agree that a crime was committed. You deserve safety.